Hi, so good afternoon to all of y'all. Today we will be completing the entire chapter. I request you all to see the first three parts also and this part and finish of this entire chapter. In your exams, this chapter alone can come for 20 marks in your new syllabus. Okay, so this is the most weighted chapter in your entire particular new syllabus EB, Economic, Commercial, Intellectual Property Law subject. Okay, so before I start, I need a confirmation from y'all that am I audible and visible, and so we'll quickly start. Okay, great. So just if in the chat box you can say if I'm audible and visible, so I will quickly start with the particular topic. Okay. Okay, great. So let's begin with the topic and continue from where we had left. Okay. Hi. So when a patent is granted, okay, after the entire process, a patent is granted to a inventor. Does this right, monopoly right, exclusive right, is forever? Answer is no. The patent has a shelf life of 20 years. After 20 years, it will go into public domain and public can also start using it and the inventor cannot file any cases. So for 20 years, the patentee, okay, the inventor is going to have a monopoly right. So the term of the patent is, remember, it's 20 years. Now 20 years from when? So if it is a domestic application, that is, it is in India only. So from the date of filing in application, so date of filing of the application in India is the start date. From there 20 years you will get protection. In case it is an application, a patent commercial transaction application, okay, which is an international application, then the 20 years starts from the date when the international application has been filed. So let's read the provisions. The provisions are given in section number 53. Section 53 covers the term of the patent. How long will the patent exist? So every patent shall be in existence for a period of 20 years from the date of filing the application for patent. In case of international application, when you applied for international protection, then or any application filed under patent cooperation treaty, then the inventor will be protected from 20 years from the international filing date. For example, if a person in USA has filed international patent on X date, so date of filing till 20 years he will be protected in the particular convention countries. A patent shall cease to have exist on expiration of the period. Okay, so if the particular 20 years is over, it will expire and will be in public domain. On cessation, okay, he will not get any protection or exclusive right. Now remember one thing, that a patent also requires to be renewed. Okay, we will see the renewal fees also. Within the 20 years also there is renewal fees that you have to keep paying to keep the patent active during the 20 years. After 20 years, it cannot be, protection cannot be given at all. Within 20 years also you have to keep paying renewal fees to keep the patent alive and get the exclusive right. We will see the term of the patent as well. So the rules, that is rule number 80. So patent rule 2003 read with section 53 will cover about the renewal fees. This I believe you can immediately tell that the term of the patent is covered under section 53. One more point to remember, it is with rule number 80. Now one thing you need to tell me, for how long does the patent exist? The patent right is for how much time period? So the answer is very simple, from 20 years from the application date. Within the 20 years also renewal fees has to be given. Now interestingly, you will see that the patent fees, renewal fees actually starts from the third year. For 2 years there is no renewal fees to be paid, first 2 years. So again, let's read. To maintain the patent within the prescribed 20 years, one has to pay renewal fees as per first schedule of the patent rule 2003. Simple. Now timing of the renewal fees. When you have to pay the renewal fee. Now see, understand, the renewal fees must be paid at the expiration of the second year from the date of the patent. So moment the second year is over, that is when the third year starts, you have to start paying the renewal fees. So for first 2 years there is no renewal fees. That means, let's say if the patent is granted, okay, year 1, year 2, year 3. So if this is the date of filing, remember we had seen, because you start getting protection from that day only. So for the first 2 years there is no filing or renewal fees. Clear till here? For the first 2 years there is no renewal fees. Now the answer is why. Understand that if I have registered a patent, I have already paid a heavy filing, I have already paid a filing fee, one. I have already incurred expenses to make the patent. Now when I have already got it patented, obviously there is no, it will take time for me to market, to commercialize my product or process. I have to now, once, even if I give a patent to you now, you will have to go to various customers, you will have to go to various industrial houses and tell that please start using. So it's going to take a lot of time and you're really not going to earn anything during initial time period, because you will take time to exploit your product, you will take time to develop your commercials, profitability, etc. So for first 2 years there is no additional financial burden. No financial burden. Now after the expiry of second year, then the inventor has to think that, listen, is my patent valuable? Is my patent having a market value? If yes, then I will start paying my renewal charges from the third year onwards. For first 2 years it is been exempted. Until then, till 20th year I have to keep paying the renewal fees. Very, very simple. Now if I don't pay the renewal fees, then my patent will lapse. It is called as lapsing of patent. And if the patent has lapsed, let's say I have not filed the renewal fees were not given, then during that time people can start using it and I cannot file a case also. Okay, so waiving of fees, when we saw, is for the initial 2 years to allow the inventors to focus on their invention without any immediate financial obligations. Now submission of the fee. The renewal fees must be remitted to the patent office before the expiry of the second year or any succeeding year. So before the year ends, before that you have to pay it. You can make advance payment also. Before the year ending you have to make the payment. Extension of payment period. So up to 6 months extension can also be given. If I could not pay the filing fees, then immediately they do not lapse it, they give you 6 months grace period also. But to get the 6 months grace period, you have to file a extension of filing fees request. That will be in form number 4. So it's very simple. First 2 years no filing fees. After that there will be filing fees. If there is if I didn't pay, I can fill form 4 and get a 6 months extension. Next, advance payment. Advance payment, that renewal fees, if I don't want it to lapse, etc., I can make annual filing fees, I can make advance payment also. Effect of non-renewal of fees. Now obviously your patent will lapse. There will be something called as lapsing of patent, that is your patent will go into public domain, and during that time the invention can be used and exploited by others, and I cannot file a case if it was during that time period when someone used it. Restoration of the patent. Okay, section 60 talks about restoration of lapsed patent. Now we will see when the timeline is over, okay, and my patent and renewal fees were not paid. Renewal fees not paid. Then under section 16, I can apply for restoration of the lapsed patents. Clear? We will see when we do section number 60. So let's see section number 60 in detail. So have you understood what is the concept of lapsed patents? What is the concept of a lapsed patent? That is the time lapsed and because of which the protection was removed or protection is no longer available because I didn't pay the filing fees. Now if I realize that, listen, I want to get protection again, then I have to apply for restoration, getting my right back. The provisions are given in section number 60, 61 and 62. Section 60 talks about application for restoration of lapsed patent. We will see how do you make the application. Then how will it be disposed of? How will the controller deal with these applications? And what is the right of the patentee with respect to the lapsed patent now being restored? So first thing is I have to make an application. Then controller will decide how he has to go, and if he decides to restore it, and what will be my rights when the patent has been restored. So let's start with section number 60. Now first let's understand the concept of restoration of lapsed patents. So it says that first the background, as I told you the background, section 53 read with rule 80 had given you certain renewal fees to be paid. The payment of the renewal fees must be completed and has to be made to the Indian Patent Trademark Office database before the expiration of the year, relevant year, as prescribed under section 53 read with rule number 80. In case the patent ceased to exist due to non-payment of renewal fees, then the patent ceased to exist due to non-payment of renewal fees. Then the patentee can opt for restoration of lapsed patents. Now, let's read section number 60. Section 60 provides that where a patent has ceased to have effect, it is no longer in effect by reasons of why it is not in effect. Because failure to pay the renewal fees as provided under section 53 read with rule number 80. So where a patent ceased to have effect by reason of non-payment of renewal fees or within the extended time period allowed under section 142, then the patentee or his legal representatives, okay, may within 18 months make an application for restoration of the lapsed patents. Okay, so what is the scene? In how much time I can make this application? Within 18 months from the date when the patent ceased to have effect, I will have to make an application, and the application for restoration of the lapsed patents will be in form number 15. So again, three important points I want you to know. It's a very, very important examiner's favorite exam question. Okay, so you will write restoration of lapsed patent. First you will write the meaning, you will quote section 53, you will quote rule number 80. Okay, then you will say that an application needs to be filed under form 15 for restoration of lapsed patents, and the provisions are contained under section number 60. In section number 60, what are they saying? Within 18 months, very, very important, within 18 months from when the patent ceased to exist, okay, when the patent lapsed, I have to make an application for restoration. Now we will see the next section, section number 61. Now when you make an application, it will be made to the controller. The controller will see that whether there are genuine reasons for you not filing it, for not paying the renewal fees. Second, the controller will ask the public also through a public announcement or publication that does anyone have a problem if we restore the lapsed patents. So even that will be done. Okay, so let's read. Procedure for disposal of application for restoration of lapsed patents. This section 61 states that the controller is prima facie satisfied that the failure to pay the renewal fees was unintentional. See, I make an application to controller, please restore it. If the controller is satisfied that the failure to pay the renewal fees was unintentional, okay, and that there has been no undue delay in making the application, maybe he had health issues, etc., he shall publish the application in the prescribed manner. Now again, let's not forget, when they publish, there can be oppositions also, there can be objections that no, don't restore his patents. And the objections could be on two grounds, two major grounds of objection can come. That the failure to pay the renewal fees was not unintentional, that is, it was intentional. And second, there has been an undue delay. Now see, if imagine that someone wants to utilize your patent, so obviously he will say that it is, he will oppose this restoration of patents. Now the controller has to give opportunity of being heard to both the parties, and then he will pass an order as he deems fit, and if he is satisfied, he will restore the lapsed patents. Okay, they will also make an entry in the register. They will, this entire details and this entire timelines will be recorded. So controller will say that it was been lapsed at this much time, then application of under form 15 was received on this date, objection was made on this date, hearings were done on this date, and my order was on this date. So entire entries will be maintained in a register. Then comes, so section 60, 61 and 62 talks about restoration of lapsed patents. Now section 62, what does it talk about? Section 62 says that when my patent has been restored, so I'll be happy or sad? I'll be happy or sad? So obviously I'll be super happy, okay, that my patent has been restored. When it is restored, I will have all the powers that I had earlier. However, during that time gap when it was lapsed, that time until it is restored, so during that time when it falls in public domain, I cannot file any cases or ask for any damages. So it becomes very risky. It's better to pay the renewal fees. Where a patent is restored, okay, the rights of the patentee shall be subject to, as conditions that may be prescribed, the controller deems fit to impose the protection or compensation of persons who may have begun to avail themselves of the patented invention. Now imagine, this is also very funny, this lapsed, so it is possible that I must have realized, I must be a competitor, I realize that he has lapsed his patent, he not paid the renewal fee, so he is not interested in the patent, okay, and therefore I started to commercially use it, exploit it, and later he is applying for restoration. So I will say that, listen, I have already begun to use your invention, patented invention, and because of that I will have a loss. I've entered into a lot of contracts, there will be disputes. So then the controller can tell that, listen, this guy, you have to compensate. They will tell the inventor that, listen, because of your non-filing and all this, there has been an issue, you have to compensate them. So then they will have to compensate, okay, and begin themselves between the date the cease to have effect and the date of publication of the restoration of patent. So between these two dates, someone must have started using it, taking steps to do some improvement, etc. So you will have to compensate if the controller deems fit. So no suit shall be commenced in respect of any infringement of patent committed between the date on which it ceased to have effect and the date of restoration of patent. This I told you. During that time, no cases can be filed. Now, let me ask you, now we did section 60, 61, 62. Now we are doing surrender and revocation. What we are doing? Surrender and revocation of patent. So, patents can be cancelled in three ways. A patent can cease to have exist. Patents can cease to exist in three ways. Either it lapses, either it is surrender, or it is revoked. So a cease, okay, a patent ceases to exist in three cases. Either it has lapsed, either the time has lapsed, or you have not restored it by paying the renewal fees, or there is a revocation, or there is a surrender. See, surrender is when the inventor himself gives away the invention and tells the patent office that I don't need this invention, I don't want to pay renewal fees, I am coming forward and surrendering it now only. So surrender can be done. Tell me one thing, should the controller pick up surrenders like this only? Okay, if he's surrendering, it is his thing, let's take it, answer is no. Controller will have to publish these details, ask for opposition, and then he is allowed to surrender. Why? It is possible I must have sold my rights and now I am coming to surrender. It is possible that I must have licensed it to someone and now I am coming to surrender. So on publication, persons can give objections, their points can be put forward. And revocation is when it is done by government, by the controller. Surrender is done by the inventor himself, whereas revocation is governed by a controller, where they find, we'll see what are the grounds for revocation. Extremely important. It is publicly known, it is of someone else, you have falsely got it, you have done fraud. So all of this, it can be revoked. So now we are seeing surrender of patents. So there is a particular sequence only. Section 60 to 62, right, spoke about lapsing of patents and restoration of lapsed patent. Section number 63 talks about surrender of patents, and section number 64 will talk about revocation of patents. Let's see. First, section 63 entitles the patentee to offer for surrender his patent at any time by giving notice to the controller. Where such an offer is made, the controller shall publish the offer and in the prescribed manner also notify every person other than the patentee whose name appears in the register having interest in the patent. So if one person has come to surrender, then I will have to inform all the parties. What if there is a licensee involved? What if there is a co-owner, co-author, co-inventor? So we will have to give to all the parties interested. Any person interested can give an opposition to the controller, and then the controller will, after hearing both the parties, either decide to surrender, revoke, or set aside the application. What is the difference between revocation and surrender? A patent is cancelled by two ways here: surrender and revocation. Surrender is a process initiated by the patentee himself, and whereas patent is revoked under section 64. Let's see. Now we are doing section number 64. Very, very important, revocation of patents. This I think you should know the section number also. Section 64. 60 to 64 all are very important. So what do you mean by revocation? Let's see. Okay, what do you mean by the term revocation? So revocation is covered under section 64 of the Indian Patents Act 1970. Revocation means cancellation of the rights granted to a person by the grant of patents. Okay. The patent can be revoked on petition of any person interested, okay, or on the grounds specified under section 64. So under section 64 there will be certain grounds for revocation of patents. On those grounds it can be revoked, and this is one of the most important questions that can be asked. On what basis can a patent be cancelled, revoked? So first, there are, I feel, around 17 points that are there. In exams they might ask you to write any 17 points. Okay, so they can obviously do such a thing. So now let's read section 64. A patent may be revoked on any of the following grounds. Before I get into this 17 points, I want you to tell me, on what grounds do you think patent can be revoked? See, it is very similar to earlier common points. Wrongfully obtained, it is not an invention. Second, you can say that priority date is there. It is it is obtained by fraud. Okay, the person who applied is ineligible. Let's see the points which are there. The biological material was not specified. So all these things can be given for revocation. So earlier priority date in another patent. If patent was granted and we come to know later on that there was another patent which had an earlier priority date, so obviously they will be entitled and your patent will be revoked. Where an invention as claimed is in a valid claim of an earlier priority date. So there was an invention and now valid claim of an earlier priority date, and it had the complete specification also. So obviously yours will be revoked if it was later on. Second is the application was by ineligible person. So where the patent application was filed by a person who is not entitled or was granted the patent. So ineligible person has come forward to, he's not the inventor. Okay, he tried to impersonate anybody, say that I am the agent, etc. So then again it will be revoked. Second, it is wrongfully obtained. The patents was wrongfully obtained. You had forged the document, you had leaked the information, you had hacked the email to get these basic things and put it in your name. Where it was wrongfully obtained and the rights of the petitioner were contravened. So those who are filing the case, we come to know that his rights were contravened. It is not an invention. Very, very simple, very, very common, that it does not fall under definition of invention. It can be challenged, and in the courts if it is found, then it can be removed. Publicly known. See, very, very important common points are there. For a patent to happen, it should be useful, it should be new, it should involve an inventive step, and it should be non-obvious. So if it is obvious and lacks inventive step, it will be rejected. If there was publicly known in any territory of India, it will be again, or any outside India or outside India, will be rejected. It is not useful. You have not sufficiently described the invention. Okay. The scope is not defined properly. Where all it will be used, what all it will be there. Maybe someone is challenging that this patent application on which you granted was wrong. Patent was granted wrongly. So on these grounds it can be revoked. False suggestion or representation. Okay, so if someone makes a false representation, false suggestion, false statement, false affidavit, it can be rejected. Non-patentable subject matter. We said not invention, we can also say it is not patentable only subject matter. For example, anything dealing with atomic energy, we saw in section 4. Section 3 or 4, anything which falls in is a non-patentable subject matter. It is immoral, etc. will not be, if registered, will now be revoked. So in revocation, grant was done and now later someone is challenging. So this is a post-grant opposition. Post-grant opposition. Secret use in India before the priority date. So it was already in use in India. Non-disclosure of information under section 8. Okay. So under section 8, if the controller has asked for any information, if there is a provisional specification and information was not given, there is a ground for revocation. Contravention of secrecy direction. Now we know secrecy direction is under section 35. If the government feels that it is the secrecy direction was contravened, again it can be revoked. It was obtained by fraud to amend. Okay, so where the permission to amend the complete specification was obtained through fraud. So there was an amendment application, and in the amendment application was actually obtained through fraud. So that can be revoked again. Non-disclosure of biological material and anticipation in local community. So more or less some of the points are overlapping, but you can use this. Okay, any 17 points are there. You will have to make a short summary. I think around 10 you can easily think of. Now coming to the next thing is that these points are same, that there should be no secret trials, one, and second, if we are discussing publicly known prior publication, the same point was there earlier also, prior publication. So if a product or process was imported, it will be assumed that it is priorly known. However, if it was only for experiment or trial only, then it will not be said that it is priorly known. Further, on petition of the central government, the High Court may revoke a patent if it is satisfied that the patentee has failed to comply with the request of the central government. Now remember, here in the Act they have given you central government, but now a special appellate board has been made, and all the powers of the High Court with respect to taking all these matters have now been transferred to the appellate board, which we will see in some time. I think it's in section 117A, which we will see towards the end of the chapter in appeals. So a petition of the central government to revoke a patent if it is satisfied that the patentee has failed to comply with the request of the central government. So one more thing, if the central government has given some suggestion and you have not fulfilled that direction, then it will be revoked. So now we did section 64 as well, very important, revocation of patents. Now we are seeing section number 65. Now section 65, revocation of patent with respect to atomic energy. So what it is saying, very simple, with atomic energy, where at any time after the grant of patent, so revocation only happens after the grant of patent, the central government is satisfied that a patent is for an invention relating to atomic energy for which no patent can be granted, it may direct the controller to revoke the patent. See what is happening. We had seen that in section number 4 it had said with respect to atomic energy it should not be registered, but if it was registered and central government had not given any permission, then the central government, now what is happening, the central government, okay, may direct the controller to revoke the patent after giving notice to the patentee and giving an opportunity of being heard. They may revoke the patent. So very simple point. Central government feels that it was related to atomic energy and no approval was given from its side, and erroneously, inadvertently, unintentionally, or in a bona fide manner it was granted by the controller. So the central government will say, listen, cancel it. It is related to atomic energy, you cannot. The controller will allow the patentee to amend his application so that it might, if amendment is possible, so, and the central government is also convinced that okay fine, if he's ready to amend his application, then we will not revoke. And section 66 deals with revocation of patents in public interest, if it is against public policy, etc. So we saw section 60, 61, 62, then we saw section 60, then we saw section 64, then we saw section 65 and section 66. This was about restoration of lapsed patents, lapsed patents. This was about surrender, okay, surrender of patents. This was about revocation of patents. 65 was also with respect to revocation, but with respect to public interest. No, sorry, with respect to atomic energy, right? Atomic energy. And 66 is revocation for public interest, in public interest. Okay, so these sections we'll have to remember. This is section 66. Okay. Now moving forward to section number 83. Now working of patented invention general principles. What are they saying? They are saying according to section 83, general principles applicable to working of patented invention shall have regard to the following general considerations. Wait, it can come in your exams. What question is this? Working of patented invention general principles. Now when they say what are the general principles prescribed under section 83, then very general philosophies, objectives, moral principles, etc. has been given. Obvious things have been given here. So first, patent has been granted to encourage invention. Agreed or no? Patents we are giving so that there is more innovation, more encouragement, more creativity involved. Second, we give them a grant for monopoly, but it does not, it's not only to grant them monopoly. Also there are purposes that after 20 years it will fall into public domain and people can use and move ahead. Okay, it is not granted merely for patentee point of view. The government also looks forward that the economy will grow, public interest will be satisfied, etc. Then the protection of patent rights. Why are we protecting and enforcing patent rights? So that there will be promotion of technological innovation. See, this is all the background for the Patent Act. Patents granted should not hamper public interest and nutrition. It should not prohibit with the central government directions, and should not abuse by the patentee to have an adverse effect on trade. Okay, it should not have an adverse effect on trade, and it should be available at fair prices in India. So if we see, what all points do you remember? One is it should be available at fair prices. Second is it should not have an adverse effect on the industry in which it operates. Then it is made to encourage innovation. It is not only to grant them monopoly, even the government is interested in developing the economy. Okay, then we have to protect the patent right so that there will be technological innovation. It should not hamper, it should not prohibit, and it should not be abused, okay, with respect to the patents that is there. Now we will see a very interesting topic, very interesting and important topic called as compulsory license. Now what is this compulsory license? When you'll understand the concept, you'll be shocked. Okay, so let's see. Compulsory license is a license granted by the controller to a third party, to an applicant, that listen, you take this and innovate, use the patentees in patents. So again, there will be three or more parties involved. One will be the controller. The second will be the inventor, or also called as here the patentee. And then we have a applicant. The applicant has filed an application to the controller that listen, I went to the inventor for license, he didn't give me the license, or the license is not granted on a fair conditions, or that he is not helping. So I am going and complaining. To the controller about the inventor, and that the inventor is destroying the industry, is not working, is not giving me, there is an urgent need of these medicines, etc. So the controller will say that, listen, they will tell the inventor, listen, this entire patent right has been given to you so that it is available at fair prices in India, so that the needs of the Indian public is met, so that if there is a medication and you're doing artificial shortage, that is not allowed. Okay, so then the controller has a right to give a compulsory license. They will give a license permission to the applicant to use the patented invention of the patentee, okay, and fulfill the requirements of the Indian public. So obviously compulsory license is not a very common thing that the controller will do, because it affects the patentee's rights. But only when public interest is involved, we will have to give these kind of compulsory licenses. So it's compulsory because it is not with the consent of the inventor. License will be given. So there was a case of Bayer versus Natco, which was the first case of compulsory license. What happened is, there were these cancer drugs which were being sold at a very high price with a huge margins. So then one of the applicant went to the controller that, listen, the inventor is charging too high prices and it is affecting the public at large. So the controller gave a compulsory license to the applicant. We will see the provisions when we read it. So compulsory license is a license or a permission given to a third party by the controller to use, sell, make the patented invention without the consent of the owner. Okay, this concept of compulsory license is there in national as well as international laws, as well as in the Patent Acts, as well as the TRIPS agreement. The prerequisite condition, now there are conditions. Obviously the controller will not just give compulsory license like this, because it affects the inventor. So there are very strict conditions given, and those conditions are mentioned under section 84 to section number 92. So let's read section number 84, the most important section in this case. So one point I will explain. Section 84 provides that at any time after the expiration of 3 years from the date of grant of patent, any person interested may make an application to the controller for grant of compulsory license on the following grounds. First is that the reasonable requirements to public is not being satisfied. That the requirements of public is not being satisfied. That it is not available at a fair price, and it is not worked in the territory of India. Okay. So this is the provision of section number 84. Now let me ask you a question. Can a compulsory license be issued within 1 year of its grant? The controller granted the patent to you today. Within 1 year, can the controller give a compulsory license to someone? Answer is no, because the act says that only after expiration of 3 years. So a compulsory license can be given only after 3 years from the time it has been granted to the inventor. Within 3 years, he can do whatever he wants. So 3 years, only after 3 years compulsory license can be issued. First point. Second, compulsory license will be given when someone has made an application to the controller on the following grounds. Now what are the grounds for issuing? So there are 3 grounds only. There are 3 grounds. One is the price, one is not worked in India, and third, it is not being satisfied. Requirements. So requirements of public are not being satisfied, it is not available at fair prices, and third, the inventor is exporting the goods only, he is not using it in India at all. So if you imagine, there was in the case of Bayer versus Natco, they was exporting the cancer drugs. They said in India nobody will be able to pay. So then they said, listen, this is one of the major grounds that it should be available at fair prices. It should meet the needs of the public, and it should be used in India as well. Okay. an application for compulsory license may be made by any person, notwithstanding that he is already a holder of a license of the patent. For example, I have a license. Let's say there is a inventor. Okay, he has licensed his invention. To a particular licensee. Okay. Still, if they feel that the terms and conditions are not adequate, the terms and conditions are extremely rigid, extremely unfair, then even the licensee will go to the controller and apply for compulsory license. And when compulsory license is applied, the controller will then decide the terms and conditions of this license agreement. Okay, so existing licensee can also apply. He can apply that, listen, till now the terms were fine, but now the terms are no longer fine. He has revised the price, he has done something which, and now his new terms and conditions are very unfair. So you can also apply. Next, every application for compulsory license to contain a statement setting out the nature of the applicant's interest. So even this you have to tell the nature of the applicant's interest. So they will have to tell that who you are, why are you asking for compulsory license, why we should give to you, how much money will you give to the inventor, how much money you are willing to give, what are the facts, what was your relation with the inventor. So all those facts also have to be disclosed. Next, the controller, on being satisfied that the reasonable requirements of the public have not been satisfied, may grant the license. So when we feel that all the three conditions, any of the three conditions were any of the three conditions which were there for granting the compulsory license is present, and he will grant the license. Now while granting this license, he will take into account, the controller will look what is the nature of the invention, whether it is medicines. Mostly it will be granted for medication and health reasons only. Okay, or if like food, etc., which is there, there might be a shortage, etc. Ability of the applicant, the controller will ask that why we should give you, will you be able to manufacture if I tell you the patented invention? So who are you? Will you be able to do? Then second, will you be able to, even if we give you the patented rights, will you be able to manufacture so much quantity? Do you have the working capital? Do you have the capital to set up the manufacturing plant, etc.? And whether the application has made, so also we will see that whether the applicant has made first genuine steps to negotiate with the inventor properly or not, reasonable terms and conditions. So can an applicant directly come, give me compulsory license? So controller will say, go and ask the inventor first, what are his terms? You try to negotiate, you show your efforts. Only when that is not there, then come to me. Okay. Then comes, however, the controller is under no obligation to take into account matters subsequent to making the application. So later what happens, then he doesn't care. It is before making the application, what all circumstances are there, that I will look into. It has been clarified that the reasonable period construed as a period for not ordinarily exceeding a period of 6 months. The reasonable requirements of public shall deem not to be satisfied if, we will see, for a not being successful within reasonable period. So here they mean 6 months. So he was trying to negotiate for a period of 6 months. Okay, then he has come. So we say, okay, fine. Then comes reasonable requirements of the public. Reasonable requirements of the public shall be deemed not to have been satisfied if the reason of refusal for the patentee to grant the license, an existing trade or industry, or the development of any trade or industry is prejudiced. That reasonable requirements of the is deemed when we will feel that the requirements of public are not met. Okay, if the industry in which it is operating is getting affected due to your non-granting of the patent, so you will be deemed, if you have given a refusal to grant a license to someone. Let's say I'm the inventor, I say I won't give, go do whatever you want. So by my refusal, if the industry in which I'm operating is getting prejudiced, prejudice means detrimental, is getting affected, is being harmed, then it will be deemed that the reasonable requirements of the public are not met. If the demands of the patented invention is not being fulfilled by the supply, a market for export is not being supplied. So imagine there is a potential of export also. So that is also not being used. So the inventor is really invented the product and just sitting and not doing anything. So a market for export of the patented article in India is not supplied or developed. So we know that if export will be done, first priority is India. Beyond India also, if there is a capacity, the controller will say please export the goods. It will generate revenue for the country. The establishment or development of commercial activities in India is prejudiced. So even if the business, trade, commercial activities is getting prejudiced, it is deemed that you have done something wrong and you have affected the public. By reason of the conditions imposed on the patentee upon grant of the license under the patent, the establishment or development of any industry is prejudiced. So because of the conditions that you have imposed. So one is refusal, right? This was directly not giving. So ideally the inventors don't refuse. They put extremely high conditions. For example, the condition will be on, I'm giving you, but give me so much royalty. A huge amount of royalty is asked. In the earlier point A, they had refused only. Then again, you impose a condition for grant of the license and put a condition of grant back option, coercive packing licenses. So any coercive means what? A forceful package licensing. So any terms and conditions are very, very harsh and non-workable. Prevention to challenges to validity of patent. Okay, so all these, some of the keywords you can take it. And the patent is not being worked in the territory of India on a commercial scale. The patented invention is not worked in the territory of India on a commercial scale. We saw, first is we'll also see whether in India you are able to satisfy the requirements or no. The working of the patented invention in the territory of India is being prevented, okay, by importation from abroad of the patented article by the patentee. If imagine you are importing the goods and not manufacturing in India, so the working of the invention in India is being prevented, affected, and not in India we are having a problem. Why? Because you are importing the article from abroad by the patentee. So again, importation is being done and it is being prevented in India. Or any other person purchasing from him, etc. is not taking proceedings, or other person against whom the patentee is not taking proceedings for infringement. So from there it is coming into India and destroying the domestic industry. So again we will believe. Since commercial licensing limits the rights of the exclusive ownership conferred by the patent, it has been very contentious, very disputed. See, compulsory licensing meddles or affects the monopoly rights. So therefore it is not that commonly given. In 2012, Bayer versus Natco case emerged as the first case in compulsory licensing. Bayer versus Natco, India's first compulsory license case. So Bayer was a manufacturer of innovative drugs. Bayer sold the drugs for this much. Natco approached Bayer for a voluntary license but was denied. Natco then approached the controller, okay, that the needs of the public are not being met and it is not being sold at affordable prices. Imagine 2,80,000 rupees is charging. Whereas NATCO said that they can sell the same drug for not more than 8,800. So the compulsory license was granted. Now, revocation of patents by the controller for non-working. Okay, so let's see. Now again, it's very simple, self-explanatory that it is not being used only in India, so it can be revoked. Let's read the provision. Section 85 provides that revocation of patents by the controller for non-working provides that where a compulsory license has been granted. Yes, sir. Okay, sorry. Let's continue. Okay. Now we'll see section number 85, which talks about revocation of patent by the controller for non-working. Section 85 states that a patent can be revoked by the controller if it is not being worked in India or not being in use. A compulsory license has been granted. The central government may, after expiration of 2 years from the date of ordering granting the first compulsory license, apply to the controller for an order revoking the patent on the grounds that the patented has not been worked in the territory of India, or the reasonable requirement has still not been satisfied, or the price is not available. So let's read. So if these three conditions are fulfilled, then if these three conditions are there and compulsory license was granted, still is not being worked, should be revoked only. Every application for revocation should contain the facts, and in case of application other than by the central government, you should give the nature of the applicant's interest. The controller, if it is satisfied, will make an order for revoking the patents. The controller has, however, put under the obligation to decide such application within 1 year of its presentation. So what is it? Let's read. Section 85 is saying the revocation of patents by the controller for non-working. That in respect of a patent, a compulsory license has been granted. The central government may, after expiration of 2 years from the date of granting the first compulsory license, feels that still now also it is not being worked, so then just remove the entire patent. Okay, that can be done, but that's an extreme case which is there, like a punishment to everyone. Now, procedure for dealing with applications. Now, very simple. Any kind of application which is there, which is a application for revocation of patent or a application for compulsory license, section 87 talks about notice and publication of the application. Where the controller is satisfied upon receipt of an application that a prima facie case has been made, he shall direct the applicant to serve the copies upon the patentee and also publish it in the official journal. What did it say? That if imagine he feels that compulsory license is there, or it is a necessary, that there is a prima facie case of compulsory license, or there is a prima facie case to revoke the patent. So then, very simple, the controller will ask the applicant who is asked for revocation or compulsory license that please inform the inventor. Then we will also tell that make a publication in the newspapers, in the patent journal, in the official journal. So there is a proper hearing of both the sides. Then obviously when we inform the inventor, the patentee, that listen, our objection has come. So then the patentee shall object within the prescribed time. Opportunity being heard shall be given to him, and after hearing both the parties, the order will be given. So very simple. If compulsory license has also been asked for, we will have to inform the inventor and hear him out as well. Powers of the controller in granting the compulsory license. Unreasonable conditions. What does it say? That when would a controller grant the particular compulsory license? So section 88 provides that where the controller is satisfied that the manufacture, use or sale of the materials, now this is also very interesting, okay, is not protected by the patent is prejudiced. Now this is interesting. I'll read it out, you tell me whether you have understood. A material not protected by the patent by reasons of conditions imposed in the patentee upon the grant of the license under the patent. He may order the grant of license under the patent to such customers of the applicant as well as the applicant. Application for license, where, so first I'm reading it out and then I'll see whether what you have understood. Where an application for compulsory license has been made under section 84 by a person who's being the holder of a license under the patent, the controller may order the existing license to be cancelled and order the existing license to be amended. Where a compulsory application is made, if an order for a grant of license to the applicant, order the existing license to be cancelled, or may be deems fit instead of ordering the asked his license to be amended. Very, very simple. Now, what did you understand from this? You read and tell me. So what it is saying? My first question to you is, the compulsory license what we are speaking here under section 88 is with respect to the license of a patented invention or of a non-patented invention. That means, is a particular question of more than one patent involved, yes or no? So let's see. Now I'll explain. Where the controller is satisfied that the manufacture of materials not protected by the patent is prejudiced. Prejudice means affected. So manufacture of a material is being affected which is not protected by patent by reasons of conditions imposed. Why? Because there are some condition imposed by the patentee upon the grant of license under the patent or the patented article. So what is happening is, there is a let's say there is the inventor and there is a particular person, okay, licensee involved, and now the inventor has put some terms and conditions in the patented application, patent X. Let's say the name of the patent or the product is product X, in such a way that it is affecting the product Y. It is affecting the technological advancement or the working of product Y. Then in such case where we realize that these terms and conditions are affecting another product which is not subject of patent, then the particular controller can ask this to be cancelled, this license to be cancelled or amended. Okay, let's understand how. So let's say there is an invention with respect to a computer program, computer article. There is a chip which is made by a inventor. Let's say this is IBM. or Microsoft. Now Microsoft has made a computer part, okay, and it has got a patent in it, where it is saying that to its particular licensees that listen, if this y'all are dealing with me, then y'all cannot deal with other manufacturers. Okay, there is a no deal with other manufacturers dealing in other products. Okay, you have to deal with my product only and you have to sell this computer only. So because of this, what is happening is, maybe if I tell a product that listen, if you are using my chip, I want you to use the keyboard of this manufacturer only, do not deal with this manufacturer. So there is like I'm trying to kill the competition in the market. So in that case, they will ask to amend or change this particular thing. So let me give you a actual example. If you know, can you all tell in the can you all tell me any editing software? Okay, editing software. So there is the best editing software is used by all creators and creators or YouTubers or those cinematographers or movies when they make is Adobe Premiere Pro. Okay, Adobe Premiere Pro. Now there is a new software that has come which is affecting Adobe, which is a direct competitor to Adobe Premiere Pro. And do you all know the name of that company? Okay, or that product which I'm talking about is Blackmagic. Okay, and Blackmagic is the name of the company, and the software that they are using is DaVinci Code. Now this is a very heavy software and a direct competitor to Adobe Premiere Pro. Now what is the Blackmagic telling its licensees, whoever wants to sell this DaVinci Code, which is an extremely powerful editing tool, which I also have. I have also downloaded and kept. It's a beautiful software and might be a replacement to the giant of the industry. Is going to dethrone the giant of the industry is the Adobe Premiere Pro. And they are giving this particular this DaVinci Code for free. They have a complete free version giving 90% of the major things which Adobe Premiere Pro is giving, and they are charging around 25,000 per year. So imagine here I'm getting for free, but then how are they earning? How is the Blackmagic earning? So what have they put a condition? They can put a condition that listen, if you're putting my software, you have to remember that you can sell only Blackmagic products. So Blackmagic products are there in other things. So the main editing software is free, but there are some other tools which are there to edit the product, like a camera or a particular tripod or these kind of editing sound tools which are there. You have to use of mine only. So this is, though the product we are dealing is a editing software, but it is affecting, the terms of the agreements are affecting tripods, cameras, other editing tools, everything else. So then this case will be involved. Now let's read and understand. Controller in granting section 88 provides that where the controller is satisfied that the manufacture of materials not protected by the patent is prejudiced. So something which is other thing only is being affected by reasons of conditions imposed by the patentee upon the grant of license under the patent. So your license under the patent which is there, that terms and conditions is affecting something which is not protected by patent. Some other thing only is getting affected. So then they will grant. He may order the grant of license under the patent to the customers. So again, very simple. So here it is possible that the competitors cannot enter into the market. So then this person will say, listen, if you also need this particular product or process, okay, you need a product or process, they will tell the competitors that you will also get it at a licensed price. Okay, will be given to the competitors and their customers on the same terms and conditions which are given to others. So understand, now I will explain the entire thing, you will understand. What is happening is, there is a patentee. This patentee has license to licensor 1 on terms and conditions which affect other competitors, and for others I am putting extremely harsh terms and conditions. So I'm trying to kill out competition. So to some I am giving good terms and conditions, and for some I am giving harsh terms and conditions. So then the controller can step in and say, listen, this kind of partiality cannot be done. We are cancelling these harsh terms and conditions, and these others will obviously have to file an application. So these will be applicants. We will tell that this patentee inventor has to give this patent to the applicant and their customers at a fair prices as given to others. This is what they have said. Okay, now so the thing is there that this harsh terms and conditions can either be asked to be amended or could be revoked or cancelled. This is what they have given. So let's read the points. First, section number 88 says unreasonable conditions which if you put in a license or purchase the products which are not protected by the patents, the controller is the compulsory license is granted under a patent to the applicant and its customers. If you put unreasonable conditions, it will be granted at fair conditions. Second, if the applicant is a licensee, existing licensee, okay, and the existing license is being turned out to be extremely harsh when it is being renewed, so then the licensee can apply to the controller that, listen, he is now started being very harsh with me. So we can tell that the existing license will be cancelled, which is harsh, or it could be amended to be allowed. And section 88 subsection 3, license to related patents can't be worked satisfactorily without infringing the rights. Compulsory license is granted for other related patents. Okay, let's see, compulsory license for a patent as well. When two or more patents are held by the same patentee and for compulsory license establishes that the reasonable requirement of public have not been met, then if the controller is satisfied that the applicant cannot satisfactorily work the license granted to him without affecting the other patents, he will ask for this thing. Revision of the terms, let's see, revision of terms only after 12 months. So whatever terms are there can be done only change after only 12 months. Termination of compulsory license can be terminated, and that is it. Okay, so let's just do a quick recap of this. Okay, so we'll do a recap of this and I will simplify it because I think it just went a little more difficult than normal. So I will explain. Patentees. Now we'll do section number 88. Section number 88 provides that where the controller is satisfied, controller of patents is satisfied that the manufacture, use or sale of materials not protected by patent is prejudiced by reasons of conditions imposed by the patentee upon grant of a license under the patent, or upon the purchase or hire or use of the patented article or process. He may grant the license under the patent to such customers of the applicant as he deems fit as to the applicant. So on reading it sounds very difficult. Let's read the entire thing, then I will explain it. Applicant is a licensee, where the application for a compulsory license made under section 84 by this holder of a license, the controller may order the existing license to be cancelled or amended. So let's see, what does section 88 talk about? Section 88 is saying that if by way of one agreement I am imposing conditions which are affecting other goods, okay, and other dealers, in such cases the controller can give you the rights to can give the terms can be amended, and the license can be amended, and we can say that give him fair terms and conditions as well. Okay, if the controller is satisfied that the manufacture, use or sale of materials is not protected by the patent, is prejudiced. Okay, sale of materials are not protected by the patent by reasons of conditions imposed by way of the patentee upon grant of the license under the patent, he may order the grant of the license under the patent to such customers of the applicant as he deems fit, as well as to the applicant. Okay, so here they are talking about there is some unfair agreement, he will rectify it. Again, if it is an applicant is already an existing licensee and the licensee is and heavy conditions are being imposed, then that existing license could be cancelled or and replaced with a fair license, or it could be amended. Then let's see the next point. Compulsory license for other patents as well. Now this is interesting. If imagine there is an inventor who is holding more than one patent, and he has granted, let's say he has patent 1, patent 2 and patent 3. Okay, we are talking of a serial entrepreneur who has multiple serial inventor. Now he has licensed this, he has licensed patent A to Mr. A. Now Mr. A realized that this license he cannot operate only without affecting patent 2. So it might be a very overlapping particular kind of invention, where if he is trying to use patent A, patent 2 is also getting affected. So he can go and write into the controller that, listen, please grant me a compulsory license for patent 2 also, because I have a compulsory license for patent A, but to use patent A or use patent 1, I will overlap on patent 2 also. So if you don't give me rights of patent 2 as well, I will not be able to use patent 1. So then he will say, okay, fine, take for both this. Let's read. Where 2 or more patents are held by the same patentee. 2 or more patents are held by the same patentee, and the applicant for compulsory license establishes, he proves that the requirements of public will not be met if the control to only some of the said patents, then the applicant cannot efficiently satisfactorily work the license granted to him under the patents without infringing other patents held by the patentee. So he's saying I cannot work for the public unless I get rights for the other patents as well. Okay, if those patents involve if those patents involve important technical advancement, economic significance, and are connected with the other patents. Then the controller may direct that the grant of license in respect of the other patents also to enable the licensee to work the patent. Very, very simple. Thus, if a person holds multiple persons, someone is granted a compulsory license for some, but can't effectively use those licenses without infringing on other important patents, then the controller will order that these compulsory licenses to cover the additional patents as well. This helps to ensure that the licensee can meet the needs of the public for specific patents covered by compulsory license. So if I get a compulsory license for one, but I say that I cannot operate this without I getting license for two also. So if controller is satisfied, he will grant it. Once the compulsory license has been given, okay, by the controller, and after discussing the terms and conditions, because even the licensee who's getting has to give some royalty, all of that was decided by the controller. It won't be given free of cost. So once I get the compulsory license and then I realize that listen, these terms and conditions which I have done is not working out, I need some more favorable terms and conditions. So then two things are there. First is only one amendment or revision of terms can be done during an entire lifetime. One. Okay. Revision can be done only once. Second, it can only be done after 12 months. So 12 months you have to use the original agreement which was entered by the controller. So where the terms and conditions of a license have been settled by the controller, the licensee may, after he has worked on the invention on a commercial use for a period not less than 12 months. So for 12 months he has to use the original license. Then he will make an application for revision of the terms and conditions, and he has to prove that revision of terms are needed because the original agreement is very onerous, very and I cannot work on this invention unless I get a loss. Okay. Next is revision can be done only once in a lifetime. So no application shall be entertained a second time by the controller. So compulsory license once granted cannot be amended for 1 year, and after 1 year you can amend it, but amendment will then not be done again. So only one amendment is permissible. Then termination of compulsory license. Now obviously compulsory license cannot be granted forever. If the patentee inventor shows that the reasons for which the grant was given is now over, it can be cancelled. Opportunity being heard will be given to the licensee also. Section 94 provides that on application made by the patentee, by the inventor, a compulsory license may be terminated provided that the circumstances that gave rise to the grant no longer exist, and an opportunity being heard has been given, an objection right has been given to the licensee as well. Now we'll see international arrangements. Which are there. So tell me one thing, a patent, can it be registered worldwide? Obviously yes. There are some provision for international worldwide patents which we will see now. First, the very first thing is definition of convention country under section 133 and reciprocal treatment to citizens. Now we had done the Paris Convention Treaty. They are all the countries which have signed the Paris Convention Treaty are called as convention countries. So ideally a convention country is a country which has signed the convention, which India has also signed the convention. So then we all become a part of the same group, and once you become a part of the same group, then the provisions of reciprocal treatment will apply. Reciprocal treatment means what? You help your inventors are protected in our country and our inventors should be protected in your country. Okay, this is what is given. Means there should be no differentiation between foreign and national. between resident and non-resident is what they are saying. Let's read. They are giving you the definition of convention country. A convention country is a country in which India is a signatory, okay, which could be any international agreement, bilateral agreement, regional agreement, okay, and that country is also signed and India is also signed. So we both become convention countries. Then the privileges that are granted to their own citizens are also granted to the member countries. So whatever privileges you are giving to your residents, you are also ready to give to your non-residents, to the other convention country members. So very simple, that if India has signed and USA is also signed, that means that we both are convention countries. The privileges that are given to the citizens of USA, those privileges should also be given to the Indian citizens. That is given in your section 133. Very, very simple. Now there is possible that, or a scenario where reciprocal benefits are not given, where there is non-reciprocal rights. So if imagine there is a country like Iran. Iran is also a convention country, but for some reason due to trade disputes, they are not giving Indians benefit of protection. Tell me one thing, should India protect them? Obviously not. It's a concept of reciprocity. You don't help us, we don't help you. So if you are not helping us and not giving your our non-residents the same rights that you give to your residents, then we also won't give you. This is what is given in section 133. So if you want registration, we will not give. If you want license, we will not give. If you want protection, we will not give. If you want to file a case, we will not give. Why? Because you are also not helping us. This is what is given here. So if any country which central government has identified is not giving benefits to the citizen of India, the same rights that they are giving to their own residents, then no person, no national of such a country shall be entitled to grant of patent under the act, registered as a assignee, or cannot apply for license also. Very, very simple. Section 135, convention application and priority date. Now this we had done initially also, and this is very, very important section. Convention applications are what? There is a convention country and a person has filed an application in the home country and is applying for international protection. So he must have filed a basic application. Basic application is he has filed a patent application in his home country, and within 12 months of filing with the home country, he is also filed a international application. So two conditions are there. He should have filed a basic application in his own home country. Within 12 months, he should have also filed an international patent protection application. Then we will say, okay, the priority date, he will also be protected, and the priority date, that is the invention, will come in his name from the date of making the basic application, from the date he makes the filing in his home country. So section 135 provides that where a person has made an application for a patent in a convention country, in his home country, and that person has made an application for a patent within 12 months for international protection, then the priority date will be the date of filing the basic application. Then comes section 136, special provisions for convention applications. Now special provisions are for convention application. Let's see. So first, complete specification. Now again, which are there for us will also be for them. That whenever anyone is filing for application in India, or because it's a Patent Act 1970 of India, so we are saying give us the detailed complete specification of the invention. 1. Specify the date and the convention country and the home country, and for all the details basically they should give. So details should be given. Then no prior application. So declaration that there is no prior application for the same invention in any other country before the Indian application. So basically you will have to tell that there is no prior application that you have already filed in any other place for the same invention. Declaration that there is no prior application for the same invention that was filed in any convention country before the Indian application. So basically like an affidavit has to be taken that there in no other country there is going to be any dispute, and no other country you have filed a separate application which you've given to the India. Next, inclusion of developments. So same way patent of addition will also be allowed here. It allows the applicant to add claims covering the improvement or additions to the original invention. So just like other applications are there, here also for this is also the same. Prohibition on post dating. So we had seen that you can apply for this and you can give a future date. That listen, the invention I am registering not today, after 1 month, after 2 months, but it should not be beyond the time that is specified in the Patent Act. So normally beyond 1 year has been mentioned. So what are the points here? Give the complete specification, give the specification of the date and the convention country, or declaration that you've not filed any prior application other than this, okay, or if inclusion of developments. So it also includes the patent of addition is also covered, and prohibition on post dating. So you cannot give a post dated beyond the date specified under the Patents Act. Then we see section 138. 138 talking of foreign patent documents. Furnishing foreign patent documents. So documents required, application must provide a copy of the foreign patent documents. We are talking of the documents that you need to provide. Okay. So the foreign documents need to be given. The verification. Verification must be done to satisfy the controller. So controller should be satisfied. Submission time frame should be within the time frame. And if it is, let's say it's a Chinese inventor, so it might be in Chinese, right? The complete specification. So a translation can be asked. So the documents could be asked to be translated, should be given to the satisfaction of them, and all the foreign documents which are there also have to be submitted to the patent registry and the controller. Then we see who is a patent agent. So a patent agent is a person who has given an exam. He's a registered professional who is permitted to give patent related advice, who will assist the individuals and companies, corporates in making patent filings, okay, in making oppositions if anyone wants to do. For example, if I want to register a patent, you would want to hire a professional, right? So there are patent agents who help you register your patent. To become a patent agent in India, an individual must pass the patent agent examination conducted by the Indian Patent Office. The work relating to drafting of specifications, the complete specification is done by them. Making applications for the patent, any kind of correspondence, side documents, supplementary documents. If objection one wants to file, so he will help you and assist you in everything, including court cases, including advising, etc. Section 125 to 132 read with the patent rules deals with the patent agent. Then patent office. Now controller of patent designs and trademark is appointed as the controller of patents. So the common controller is appointed as controller of patents also. There will be an office. There shall be an office. Obviously they have something called as a patent office. The patent office headquarters is in Kolkata, and the other patent offices are in Delhi, Chennai and Mumbai. Central government may in the official gazette specify the name of the patent office. Now we come to appeals. Now earlier the patents or the appeals were made to the High Court, But now this has been done away with, and now we have something called as a intellectual property appellate board. So maybe in your modules you can make a correction. In the grant of patents is refused by the controller. So let's say if someone there you have an issue with the controller. So from controller you will go in appeal to the intellectual property appellate board, and from there is no further appeal. Okay, there is no further appeal that can be filed. So this is the one appeal and final appeal. You can apply for review, but there is no higher authority that will hear the matter than the intellectual property appellate board. Okay, the board was established in 2003 to decide all the appeals from the orders of anything which was earlier coming under the High Court. Now see, the High Court judges were not well equipped to deal with technical matters. Now in intellectual property law or the board, there are experts of intellectual property, technical experts, so that and their decisions will be final, because we want to bring an end to litigation as well. So section 117A talks about appeals to intellectual property board, which was earlier the High Court. Section 117 of the Patents Act deals with that the appeal shall lie to the appellate board against any decision, order, direction issued by the controller. So earlier here there was written the High Court. Now it is the appellate intellectual appellate board. Time limit. The time limit is within 3 months from the decision of the controller. Further appeals. So once the board has given the order, there is no further appeal that can lie to the High Court or Supreme Court. The decision of the appellate board is final and unappealable. And that is it. We've completed with the entire chapter of Patents Act 1970. Everything and no question can be framed outside from what we have done. Thank you so much. Okay. Till here, have you all understood? I've covered the entire chapter. Yes or no? So the entire chapter, including the earlier parts, I have covered. Please go ahead and study those chapters and keep it aside. 20-mark chapter it is there. So that is it for today. The balance, the next schedule, I will give it in our WhatsApp and Telegram groups. Do go ahead and join it. It is there in our this, and also you can click the bell icon so that whenever we come live you will come to know. Okay, great. Thank you so much, Sona. I hope the entire chapter is absolutely clear. Okay, great. So that's it. Now I'll tell the schedule for the next lectures soon. Take care, guys.